Are you looking at filing for a divorce in Wisconsin but find the process to be so confusing? What is the criteria and what forms do you need? And where do you go to get them? And finally, how do you notify the other party? Well, this video with Holly and I will answer all of those questions. Well, hello and welcome to the Wisconsin Family Law Insider. My name is Jeff Hughes and I'm the CEO of Sterling Lawyers. We are a family law focused law firm. My co-host is also with me. Holly Mullin is our managing partner. She oversees and leads our team of lawyers and paralegals and legal assistants. So welcome, Holly.
Thank you, Jeff. I really appreciate you having me here today.
You know, the topic that we wanted to talk about today was how do you get a divorce action going? I know this can be really confusing for a lot of folks with where do you get the forms, what goes in there and so forth. So let's walk through for our listeners exactly how they go about doing this process and doing it correctly so the judge will accept it and not kick it back for a correction or something. So initially, what's the first consideration for a party choosing to file for a divorce?
So first and foremost, we need to make sure that Wisconsin is the right place. So, every state has unique jurisdictional requirements to ensure that cases are being filed in the right location. So in Wisconsin specifically, you have to have lived in the state of Wisconsin for 6 consecutive months immediately before you file a divorce action. And then narrowing that even further would be you file it in the county that you've lived in for the last 30 days. So you have to be in the state for 6 months and then in any specific county for 30 consecutive days. And then you have the right to file a divorce action here.
When you say live, that's literally lived. I mean, like you sleep here, this is your home. And it's not just a mailing address or a driver's license location, right? Is that how the court looks at that?
Yes. I mean, and I'll carve out one sort of small caveat to that, which would be for active military service members. So if somebody is serving our country and they are either out of the state or even out of the country, if their residence is Wisconsin, that doesn't change just because they're on active duty. So them not living here, if they're on serving duty, then it doesn't change their residence. But aside from that, what you described is correct. You actually have to live here.
So once you know that hurdle has been crossed, what's the next step in the process?
Next comes the paperwork.
Okay, fun.
Lawyers love to talk about. So the paperwork for the divorce, you have your primary initial filings, which is the summons and petition for divorce. They're technically separate documents, but they really go hand in hand together to get the divorce started. So the summons is the notification to the other party that you're filing an action technically against them. It's notification that you've been named in a lawsuit. That's a summons. And it gives them certain direction of, look, it's been filed in this county. This is the timeline that you have to respond to this action. And then it is attached. So that's the summons. It's the notification to the other party. And then the petition is attached to that. The petition is your request to the court to start a divorce action. It's your request to initiate divorce proceedings. And the content in there is relatively straightforward stuff. It's your biographical information, name, address, date of birth, where you were married, when you were married, are there any kids? And then it's also the specific requests that you are seeking in the divorce action itself. So you are asking the court for certain orders. Those orders might be placement of the children or custody of the children, property division and debt division, whether any support, whether it be child support or maintenance would be involved. And then most obviously, it would be divorce. You're asking a judgment of divorce. So you actually lay all of that out in the initial divorce pleadings that you're filing with the court.
And you're also indicating to the court your belief that the marriage would be irretrievably broken if you're looking for an actual divorce, correct?
Yes, that's correct. So we don't have any, you don't have to prove up any grounds to get a divorce in Wisconsin. It's a no-fault. So as long as you indicate that the marriage is irretrievably broken, as long as the petitioner, meaning the person asking for the divorce, indicates that they believe the marriage is irretrievably broken, that is the standard. So you don't have to prove somebody was at fault, it's an improvement. Nobody needs to air out the dirty laundry in court, so to speak, in order to get a divorce, as long as one of the spouses believes the marriage to be not reconcilable, they will be able to obtain a divorce judgment.
And it's just one of the two that has to state that, right?
Correct.
You also mentioned there that you would include in this petition the things you're asking for from the court. And I wanted to camp on this for a moment and kind of unpack it because I have seen a lot of clients come in and be really upset that their spouse was asking for something that probably didn't fit with the type of case they had, like if it was a short term marriage, asking for maintenance. And is it true that you've seen a lot of people just put everything in there and request it, knowing that they can detract it later?
Yeah, I love that question actually. So I can say I personally try not to do the sort of kitchen sink type petition. Number one, it's not helpful. It actually can set a really negative tone at the onset of a divorce that can be otherwise avoided. Like, for example, asking for sole custody and primary placement and alimony slash maintenance, right? Like, you can ask for all of those things, but let's say this is a relatively amicable case where you expect actually to co parent and share placement of the kids, and that maybe you're relatively equal earners where neither of you are actually going to be seeking out maintenance from the other. Asking for those kinds of things at the onset and including it in the papers can really put somebody on the defensive if they're the one receiving those papers and they say, whoa, 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 like, you're trying to take the kids from me? You're asking me to pay you maintenance of. So I really do try to tailor it to the needs of the client that I'm working with. Like, what is it that you're actually looking for? Because you can easily say allocation of placement of the children, support as may be appropriate under the circumstances. So it's like you're not waiving your right to ask for those things in the case, but it's certainly that's a much more palatable approach, to
Right.
receive documents saying, okay, we have to work out a placement schedule, as opposed to like, oh, my spouse is asking for primary placement and I'm just being removed from the picture. Like it feels different to be on the receiving end of that. So we do try to be thoughtful of what
Yeah.
we're asking for in there.
That's just indicative of looking at the whole big picture and not coming in there with your chest out and posturing this tough person sort of a mentality when you don't need that. It's a lot more, and it'll end up being a collaborative in most cases, just working together. So why do that? Why poke the other person in the eye just to do that in the beginning?
It's so true. I mean, and because you are setting a tone for a case. I mean, it's not the case is going to last a while, a minimum of 4 months in the state of
Mhm.
Wisconsin. 120 days from the time that you serve the papers until you can get your divorce. So how that 4 months looks and feels is largely driven by the people going through the divorce and the attorneys that they choose. And if you can keep things relatively low conflict, it's going to keep things lower cost. It's going to salvage opportunities for healthy co parenting after the divorce is done. So, wherever I can, I try not to throw gasoline on a fire. It's not serving the client's benefit, that's for sure. So, if we can be just a little bit thoughtful in the way we're drafting these petitions, it can make a pretty big difference in the way that the other person is going to receive this and therefore respond to the entire proceeding.
So, with respect to the actual paperwork, there's two places to get that. As we know, you can go to the county courthouse and they'll give you a packet, I believe, where you can then fill it all out. And there's instructions with that. But you can also go online and get it as well. Is that what you've seen where people that are filing on their own typically find
Yeah.
this paperwork?
Yeah, there's the circuit court forms. So all of Wisconsin's circuit court forms are available on the circuit court website. And if you can choose, when you get to their forms, you can see that they have, everything from civil cases to probate cases to family law cases. So you would click on the family forms and it'll give you a slew of options, everything from the documents I just referenced, so the summons and petition, to financial disclosures and parenting plans. And it's quite a resource out there of forms that are available to individuals looking to file.
Mhm. Yeah. So once the paperwork's filed properly and it's been received by the court, there's been the filing fee paid and all of that. There's one big step that's next to make it official, and that's the service component. So walk us through kind of the different options and the pros and cons of each of these options.
Yeah, so this is a conversation I I am sure to have with every one of my clients, which is explaining that there's options for this. Because again, just as we were talking about with throwing everything into a petition, um, we can be thoughtful about the way we serve an individual. So, of course, you could go on one extreme and get a sheriff's deputy to serve them at work. You can,
Hmm.
you know that they're going to be there, and you could send them over there, and to the far extreme of that is you could ask them to sign a joint petition. You could say,
Yeah.
hey, I'm going to be proceeding with a divorce. Are you willing to sign with me? And then we don't have to serve either one of us, right? It's just like we're
Hmm.
mutually asking the court to start this divorce, and then we don't have to serve one another whatsoever.
Yeah.
So you can see there's quite, a polar extreme of how you can approach this.
Hmm.
Um, let's say the other party isn't necessarily interested in filing for the divorce. That doesn't mean then you default to the sheriff's deputy at work. You
Yeah.
can, um, your attorney, for example, could email them and say, here's a copy of the documents. I'm trying to take a low conflict approach to this, and I've attached something called an admission of service. This
Hmm.
document simply acknowledges that you've received copies of the initial papers that I have filed. If you're willing to sign that admission of service, I can avoid the need for a process server or sheriff's deputy.
Yeah.
And it might be surprising to some. It's like I get that document signed most of the time. Most of the
Hmm.
time, people are willing to sign that. They don't want a process server or sheriff's deputy showing up at their house when their kids might be home or at their work and surprising them or embarrassing them. And so the admission of service it's a real simple, like 2 sentence document. Like,
Yeah.
I am the respondent in this action and I admit receiving copies of the documents. You're not
Hmm.
otherwise giving up you're not agreeing to property division or any financial
Yeah.
component. You're simply saying, yep, I am acknowledging that I got served.
Yeah.
So you don't need to hound me with a process server. That's really all you're acknowledging. And certainly I think most people will appreciate that you're giving them that option. So that's my approach usually. I mean, certainly there's cases where exceptions will be warranted, right? If there's abuse or, we have like an exit strategy that needs to be followed. But in your kind of average case, an admission of service can be a good approach on a low conflict basis to get the service accomplished. And if they choose not to, right? If they choose not to sign that admission, then they understand that it wasn't an aggressive tactic to get them served. It
Right.
was they chose not to sign the admission, so they know this is coming and they can't later say, why would you possibly do that to me?
Yeah. I mean, I've experienced that almost everybody signs that once they understand that they're not giving up their rights and they're not agreeing to anything. Because people are always nervous, aren't they, about signing any paperwork when it's a legal case in front of them? So that's very normal to feel that way. You didn't mention one other option. I had a case one time. This is an option that everyone should not do. So let me just stress that on the front end here. But I had a client come in to see me one time, and she was livid, upset, and through the course of that initial consultation, I was kind of probing really what was trying to figure out what was going on, right? And I asked her how did she get the paperwork, and she said that they have a stack of where they keep all their bills, and apparently he goes out and hires a lawyer. The lawyer files everything. Don't They didn't tell her, didn't tell my client, and then he put all that paperwork within the bills along with a new lease that he just signed attached to that he was moving in with his girlfriend. And yes, it was the worst, most passive aggressive move I've ever seen. He didn't have enough guts to tell her he was filing and give her the paperwork. He just kind of left it so in a place where she would find it. And it just devastated her. And it set us back probably 6 months in the case because it didn't need to be as difficult as it was. But it kind of put us off on this wrong footing. And for the first 6 months, it just seemed like there was so much emotion we had to work through to get to the issues and resolve the
Absolutely.
case.
That
So
was
don't do
that
that.
was going to be, yeah, that was going to be my question, Jeff, is, and how did that work out for him? How did that
Not,
divorce end up
no, yeah,
going? It's just like so many of these, some things in a divorce are going to be outside of your control, but there's certain things within the divorce that we can control and that we can influence. And why not try to make that to the party's advantage? Like,
yeah,
Right. I can only imagine that what you saw happen in that case really made it spiral for the first several months while people just got their bearings back.
Yeah. Well, thank you. And we really hope that you found this video helpful. And if you did, there's a lot of other videos on our YouTube page that are designed to help people just understand how the process works and how to do that as efficiently and as smoothly and as harmoniously as possible under the circumstances.